Thank you very much for giving me yet another opportunity to discuss a very, very important subject in the context of some theories that I have come to develop through my study of the doctorate of law, particularly in the subject of or the topic called Ubuntu and the law towards a new constitution or dispensation, which I have dubbed the Lubogo framework in terms of Ubuntu constitutionalism. One of the fundamental things that we need to do at PhD levels is to develop things that help. So it's a complete philosophical but also framework. So there are about 20 theories that have helped me to synchronize some of the discoveries, if you like, discoveries in quote, or what I've dubbed the Lubogo framework as far as constitutionalism and Ubuntu is concerned. So before I examine any of the 20 theories, we must sit in a single unsettling fact. For more than a century, African legal systems have operated under structures that were never designed for African societies. Colonial law did not simply replace indigenous law, it suppressed it. It coded Ubuntu and other communal justice mechanisms as informal, subordinate and lengthy, and unauthorized. Then at independence, post-colonial constitutions inherited that suppression without dismantling it. So the result is a profound and largely unexamined condition. African courts today routinely apply Ubuntu values operationally while remaining semiotically estranged from Ubuntu as named constitutional signifiers. So in plain English, judges do Ubuntu work but cannot say the word Ubuntu. They produce outcomes that are Ubuntu constant without ever citing the normative foundation that justifies those outcomes. So this is not a harmless linguistic accident, it's a structural pathology that I come up in terms of identifying what I named the Ubuntu decolonization deficit. The Lubogo framework is the first comprehensive, operationalized, multi-judiciary applicable response to that deficit. It comprises 20 original theories, tests, principles, and doctrines evolved between 2024 and 2026 in terms of the writing, but go back as far as about 9 to 10 years back. And some of them have been supplied now to the International Journal of Semiotic of Law in Colombia, Human Rights Law Review, and also other journals in terms of humanities, like Harvard Law Rights Journal and others in Yale. So the framework is organized in terms of what they call 5 clusters, each addressing a distinct failure of the current law. The cluster 1, the Ubuntu deficit cluster, addresses selective position and fragmented accountability. Cluster 2, the irreversibility cluster that addresses permanent non-rich remedies in terms of loss. And then others, cluster 4, for example, talks about the semiotic and constitutional cluster that addresses the deepest structural conditions why Ubuntu remains unnamed in courts that actually apply the values. And then cluster 5 in terms of measurement and diagnostic cluster that provides the tools for audit in terms of all the above. So each theory becomes an original intellectual contribution. Together they constitute a unified jurisprudential framework that transforms Ubuntu from an ethical memory into constitutional diagnostic tool. So a judge can apply it, a lawyer can argue it, a citizen can demand it, and Law Reform Commission can audit against it. So we may begin with cluster number 1. Get ready. Listen, as far as cluster number 1 is concerned, the Ubuntu deficit cluster is what I termed or dubbed as cluster number 1. In terms of this, I have generated 4 theories, and these are the ones that I'm going to discuss as follows. The cluster comprises of 4 interconnected theories, emerging primarily from the analysis of selective prosecution in the Karamoja Iron Sheets scandal and the conviction of Agnes Nandutu. So together they constitute a relational theory of criminal justice accountability grounded in Ubuntu's ontology of relational personhood. The problem that demanded this cluster is when you consider, for example, the Karamoja Iron Sheet scandal, multiple actors were actually involved in the diversion of iron sheets that were meant for vulnerable communities. Yet only a few individuals were actually prosecuted. Agnes Nandutu was convicted. Others, including high-level political figures, faced no consequences. The prosecution did not occur where, they did not occur where legally valid. The correct procedures were actually followed. The convictions were lawful, but something was deeply wrong. And that is something that I'm about to reveal. The wrongness did not lie in any single legal error. It lay in the structure of accountability itself. Collective wrongdoing was collapsed into individual guilt. Institutional causation disappeared behind procedural closure, enforcement became narratively selective rather than structurally coherent. The result was fragmentation disguised as justice. And fragmentation, as I write, is more dangerous than the failure because it still looks like justice. So this condition is what the Ubuntu deficit theory does diagnose. And the Ubuntu deficit is not a moral observation, it is a jurisprudential diagnosis. It identifies the precise point at which the criminal justice outcomes, while legally valid, fails to achieve rational completeness. So the deficit arises when systematic wrongdoing collapses into individual guilt, institutional causation disappears behind procedural closure, and enforcement becomes narratively selective rather than structurally coherent. Now, theory number one in terms of the Ubuntu deficit theory would be as follows. The Ubuntu deficit theory provides the foundational diagnosis for the entire cluster. It argues that collective wrongdoing prosecuted selectively produces a structural disintegration of relational accountability. So the deficit is not a matter of judicial error or procedural malice, though both may actually be present. It is a structural condition of the criminal justice system itself. So the theory identifies three characteristic features of an Ubuntu deficit. First, the systematic wrongdoing is collapsed into individual guilt. Only the lowest, perhaps, or most vulnerable actors are actually protected, while institutional architects remain untouched. Second, institutional causation disappears behind procedural closure. The state closes as if its file having prosecuted someone, but the full causal claim remains unexamined. That the enforcement becomes narratively selective rather than structurally coherent. So the story the state tells about accountability is not a story of how the harm actually occurred, it's a story of who was convenient to prosecute. The theory also transforms a diffuse moral complaint about selective prosecution into a structured constitutional diagnosis. It provides a name for what has actually long been left but never theorized, and that prosecution can legally be corrected yet rationally broken. So the Ubuntu deficit is that brokenness. Why this matters for jurisprudence? Conventional criminal law theory has no category for legally valid but rationally incomplete justice. It knows legality and illegality. It knows procedural correctness and procedural error. It does not know fragmentation. Ubuntu deficit, therefore, introduces a category. It moves justice from a binary to a spectrum. The novel issue raised here is that the theory introduces the concept of rational completeness as a freestanding constitutional requirement. It argues that a prosecution that can be lawful and yet constitutionally deficient because it fails the test of rational completeness. So this is a generally novel claim in criminal jurisprudence. Who benefits? The lawyers, for example, in terms of the defense, lawyers can gain language to challenge the selective prosecution beyond conventional equality argument. Courts gain a diagnostic tool. The public gains a framework to demand that justice cannot be merely correct but complete. So how can it be employed? A lawyer can invoke the Ubuntu deficit theory by demonstrating that the prosecution, against their client, while procedurally correct, is rationally incomplete because it omits high-level actors, transcends the causal chain, or even serves institutional relief rather than the moral coherency. Theory two would be in light of what they call the Ubuntu deficit test. The Ubuntu deficit test is an operational instrument of the Ubuntu deficit theory. It is a structured four-question test applied analogously to a constitutional proportionality test that ensures that the rational completeness of criminal accountability in any given prosecution. So the test transforms Ubuntu from an ethical tradition into a constitutional evaluative doctrine capable of testing the moral completeness of a criminal justice itself. Now, the test does not ask whether the law was correctly applied. It asks whether justice was rationally achieved. The four questions are these, and these are important in the context of the discussion that I'm presenting. The first is, was accountability applied consistently across similarly situated actors? The limb examines whether the prosecution is selective in ways that cannot be justified by legitimate procedural criteria, where similarly placed actors are actually traced differently without adequate explanation. So the first limb reveals a deficit. Second, was responsibility mapped across the full causal chain in terms or trust at convenience? So the limb examines whether the prosecution has stopped at the most convenient actor while leaving constitutional or even higher level causation unexamined. So where the causal chain is tranced, the second limb reveals a deficit. Now third, Does the outcome restore relational balance or even merely conclude a prosecution file? The limb examines whether the outcome achieved something meaningful for the community harmed or merely allows the state to close its file. So where the outcome produces administrative closure rather than rational restoration, the third limb reviews a deficit. Now, in terms of the fourth, does the result produce moral coherency or institutional relief? The limb examines whether the outcome makes moral sense to the community affected, or whether it serves primarily to the relative to relieve institutional pressure, whether the outcome produces institutional relief rather than the moral coherency. And the fourth limb reveals a deficit. So where the answers reveal fragmentation, an Ubuntu deficit is actually established and the outcome is constitutionally suspect, even if procedurally flawless. Why this matters for jurisprudence? This theory, what I've dubbed the UDT, gives courts a structural framework for evaluating not just legality but relational integrity. It moves Ubuntu from aspiration to operation. A judge can now apply the following test just as they apply proportionality test as to assess whether a prosecution has actually achieved relational completeness. So in terms of novelty, the novel issue raised here is the test imports the structure of constitutional proportionality analysis into the evaluation of criminal prosecution. So this is unprecedented. Proportionality has actually traditionally been applied to rights or limitations, not to procedural decisions. So the UDT extends proportionality style reasoning into a new domain. So who benefits? Judges can gain a structured framework that disciplines discretion, that, in terms of defense lawyers who gain justiciable test proportionate, prosecutors can also gain a self-audit tool, law reform commissions can actually gain a standard against which to evaluate procedural patterns. How can it be employed? A lawyer, for example, representing an accused in a selective prosecution case invokes the UDT and asks the court answer each of the 4 questions on the record. Where the state cannot show constituency across similarly, situated actors, the burden shifts. Where, for example, the causal chain is crossed, the court must explain. The test transforms a diffuse moral complaint into a structured constitutional inquiry. Now, if you argue in terms of theory 3, what they call the rational criminal jurisprudence, I would argue in terms of this. The rational criminal jurisprudence is the British jurisprudential concept in the Ubuntu deficit cluster. It argues the criminal law must evolve beyond methodological individualization into a framework which guilt is not denied but contextualized within the full causal architecture of collective wrongdoing. Justice is no longer about who did the wrong, but about how wrongdoing is structurally assembled across institutional relationships. Yes, so this theory will challenge the foundational assumptions of modern criminal law that guilt is an attribute of individual factors, acting on their own violation. While individual violation remains relevant, the theory will argue that much modern wrongdoing is institutionally structured. So iron sheets are not just, for example, diverted by a single minister alone. They are diverted through a chain of officials, approval failures, oversight, and systematic incentives. So to prosecute only the last actor as in the chain is to misunderstand how the harm does actually occur. So rational criminal jurisprudence does not, argue for abolition of criminal law. It argues for the deepening of individual accountability in terms of it should not be abandoned. So it's contextualized. The question is no longer only whether the accused did wrong, but how the wrongdoing relates to the larger pattern of institutional action and even inaction. So justice requires that the full architecture of causation be examined, not tossed at convenience. So why this matters for jurisprudence? Criminal law theory has actually been denominated or dominated by methodological individualism for centuries. Rational criminal jurisprudence offers a systematic alternative grounded in Ubuntu ontology for rational personhood. It's not a mere adjustment, it is a foundational reorientation. In terms of the novelty, the novel issue raised here is that the theory raises the question whether criminal guilt can actually be fully determined without examining institutional causation. It challenges the conventional separation between individual criminal responsibility and institutional or even systematic accountability. It argues that these are not separate inquiries but integrated ones. Who benefits? The courts can gain a framework for understanding complex, institutionally structured wrongdoing. Legislature gains a theoretical foundation for criminal law that reaches beyond individual factors. The public gains more accurate account on how harm actually occurs in a complex system. How can it be employed? A court applying rational criminal jurisprudence would not stop at inquiry at the individual accused. It would ask what institution and systematic factors enabled the wrongdoing. It could demand that prosecution map the full causal chain, not merely identify the convenient culprit. It would treat the absence of institutional accountability as a relevant factor in evaluating the individual guilt. That is fundamentally important. And then if you argue in terms of theory 4, what I would argue in terms of the relational accountability theory. Relational accountability theory adds that accountability in criminal prosecution, not merely procedure. It is rational selective prosecution. It is not just an equality problem. It's a relational justice failure that ruptures the communal bonds of Ubuntu required between the state. So the accused, the victim, and the wider community. So where accountability is selective, Ubuntu is violated structurally. Okay, so the theory argues that a system that cannot distinguish urgency from opportunism, is not cautious at all. It is blind, it's rational, it's irrational accountability. It requires the state's enforcement pattern, in terms of coherence with the community's sense of who is accountable and who is, and for whom and for what. So the enforcement becomes narratively selective and the state loses its moral authority to punish at all. Yes, so the theory draws on Ubuntu understanding of accountability as the process of restoring broken relationship, not merely assigning blame. So under Ubuntu, accountability is not only complete when punishment has actually been inflicted. It is complete, for example, when relationships have actually been repaired. Selective prosecution cannot repair a relationship because it does not address the full pattern of harm. It leaves community members knowing that accountability was actually partial, that some actors were protected while others were actually sacrificed. So why this matters in terms of jurisprudence? Rational accountability theory adds a dimension that conventional accountability theories miss. Accountability is usually understood as a matter of unanswerability and sanction. Relational accountability theory argues that these are sufficient. True accountability must also restore the relational bonds and that harm the rupture. And then the novelty here could be the theory introduces the concept of rational restoration as a measure of accountability completeness. So it argues that a prosecution that does not contribute to rational restoration is accountability incomplete, even if procedurally correct. So this is a level standard that goes beyond conventional legal measures. Yes, who benefits? Very important. The victims of collective wrongdoing benefit from a framework that demands accountability for the full pattern of harm, not just isolated actors. Communities benefit from restored relationships. The state benefits from regained moral authority. Important as well. How can this be employed? A court applying relational accountability theory would not only ask whether the accused is guilty, but whether the prosecution as a whole contributes to a restoring relationship in terms of relational balance in the affected community, where selective prosecution leaves community relationships ruptured, for example. So the court would find the accountability process incomplete and would actually demand remedies beyond individual punishment. Very, very important in the context of that wonderful theory. So I will continue by talking about cluster number 2. Cluster number 2 had to do with what they call the irreversibility cluster. The irreversibility cluster. And in this particular cluster number 2, I argue in terms of 4 theories that I want the world to take serious note of. This cluster comprises of 5 theories developed across submissions to the Columbia Human Rights Law Review, to Yale Journal of Law and Humanities, the Harvard Human Rights Journal, and the Mufumbiro essay. So together they constitute a new mode of constitutional adjudication for cases involving permanent, non-remediable human loss. And the problem that demand this cluster is what I want to argue now. Listen, some losses cannot be remedied, okay? No subsequent acquittal, no appellate correction, no constitutional remedy can restore a missed barrier. For example, a child who dies while a parent is in pretrial detention cannot be brought back for a second funeral. A medical procedure that becomes impossible due to delay cannot be rescheduled. A final goodbye that is refused because it cannot be reenacted. So these are not merely harmful outcomes, they are final outcomes. So yet conventional constitutional reasoning treats them as just another factor to be balanced. So speculative risk or fight is weighed against certain irreversible harm. This is not balancing, it's blindness. Liberal constitutional reasoning, as theorized by Dawkins and Alexie, systematically under theories reversibility. The law has actually evolved sophisticated tools for balancing competing interests, but has no special treatment of harm that cannot be balanced away because they cannot be remedied. So the irreversibility cluster addresses this blindness, and this is the importance of this particular cluster. So I would argue in terms of the 5 theories. The first theory will be in the context of if not but, the principle. If not but. if not but as a principle. The if not but principle is the anchor in terms of this cluster, where law produces avoidable, irreversible harm despite the availability of less restrictive alternatives. It must explain not only as in its action, but its refusal to act otherwise. The principle functions as a counterfactual demand into constitutional reasoning. Courts might justify merely what they did, but they must be inclined to do what the dignity preserves in terms of preserving an alternative in this particular issue. So the principle gets its name from its structure. If a less restrictive alternative does exist, but the state did not adopt it, then the state must explain why not. The burden shifts. Silence is not permitted. The principle is grounded in Ubuntu insistence that the law serve human dignity not merely as its own procedural integrity. Okay, so where a dignity preserving alternative is available, the state as a failure to adopt it is a deficit, is a serious deficit. So why this matters for jurisprudence? The principle introduces counterfactual duty into constitutional adjudication. Courts are accustomed to reviewing what the state did. They are less accustomed to asking what the state could have done, but choose not to do. So the if-but principle makes the counterfactual inquiry mandatory. So novel issues in terms of this, the principle raises the novel question of whether the state omission can actually be constitutionally insignificant as a state action. So where the state fails to adopt dignity-preserving alternative, for example, that failure is not new to omission. It is a positive choice that must be justified. So who benefits? Every person facing state decisions, that could cause irreversible harm benefits. Courts benefit from a clear principle that guides review of state inaction. So human rights bodies gain a doctrinal tool for evaluating state failures to adopt less restrictive alternatives. How can it be employed? A lawyer, for example, invokes the if but not principle by identifying a dignity preserving alternative that the state could have adopted but did not. So the lawyer then argues that the burden shifts to the state to explain why that alternative was rejected. If the state cannot provide an adequate explanation, the principle establishes a violation, and that is fundamentally very important. In terms of theory number 6 would be in terms of the Ubuntu counterfactual test. The Ubuntu counterfactual test is the operational mechanism of the if but not principle. Courts must answer a single diagnostic question. If a less restrictive dignity preserving alternative existed, why was it not adopted? Silence in the face of the question is itself a violation of the right of human treatment under Article 10, Subarticle 1 of the International Covenant of Civil and Political Rights. So the test is named Ubuntu counterfactual because it derives its normative grounding from Ubuntu's account of relational dignity. So under Ubuntu, dignity is not merely an attribute of the isolated itself, it's constituted through relationships. So a deprivation that subverts relational bond is qualitatively different from a deprivation that merely restricts movement. So the counterfactual test captures that difference by asking the state to justify not just the deprivation, but the refusal to adapt a relationship preserving the alternative. Fundamentally and extremely important. So the test is designed to be simple enough for routine application, but rigorous enough to produce real accountability. The single question, if an alternative existed, why was it not adopted? The court must answer, silence is a violation. Why this matters in terms of jurisprudence? The Ubuntu counterfeit test provides a clear, justifiable standard for evaluating state decisions that risk irreversible harm. It does not require complex balancing. It requires answer to a single question. That simplicity is a strength, not a weakness. So the novelty here that I'm raising is that the test treats judicial silence as a constitutional violation. A court that fails to ask the counterfactual question has actually failed in its duty. This is a novel expansion of judicial obligation. So who benefits? Detained persons benefit from the test that forces courts to consider the alternatives. The appellant courts benefit from the clear standard of review. Human rights monitors benefit from a simple diagnostic question. So how can it be employed? A lawyer, for example, representing a detained person invokes the Ubuntu counterfeit test by identifying a less restrictive alternative and demanding that the court answer the why the alternative was actually not adopted. And the lawyer who argues that if the court cannot answer or answers inadequately, the detention violates the right of human treatment. Fundamentally important. Then if you argue in terms of theory number 7, the doctrine of irreversible harm, in terms of that aspect, we are saying that the doctrine of irreversible harm provides the structural reordering that makes counterfactual test meaningful. Where, for example, legal deprivation produces a permanent, non-remediable loss that forces a human experience that no subsequent judicial order can actually restore. The constitutional balancing exercise must be fundamentally reordered. Speculative risk cannot outweigh certain irreversibility. That is extremely important. And then the doctrine shifts the entire frame of bail and detention jurisprudence from managing speculative risk to preventing a certain permanent loss. No subsequent acquittal, no appellant correction, no constitutional remedy can restore a missed barrier. The denial is not merely harmful, it is final. Courts must recognize finality as a distinct category within its own weighing. So under the doctrine of the unusual balancing test, it is actually inverted. So ordinarily, courts outweigh the risk of flight or danger against the accused's interest in terms of liberty. So where the irreversible harm is at stake, the analysis changes. The state must show not merely what is interest is legitimate, but also no dignity preserving alternative could actually serve the interest. Speculative or minor state interests cannot outweigh certain irreversible harm. So why this matters in terms of jurisprudence, the doctrine of irreversible harm introduces the hierarchy of harms into constitutional adjudication. So not all harms are equal. Harms that cannot be remedied are entitled to greater weight than harms that can be. So this is a significant departure from the standard balancing approaches and fundamentally important in terms of jurisprudence. Now, the novelty here is that the doctrine raises the question of how courts should identify irreversible harm and what evidentiary standard should actually be applied. It also raises the question of whether some state interests are simply too speculative to outweigh certain irreversible harm. So who benefits? Every person facing a state decision that could cause irreversible loss benefits. Family benefits, from knowing that the courts will actually take finality in seriously. Courts benefit in terms of a clear doctrinal framework. Yeah? And how can it be employed? A lawyer invoking the doctrine of irreversible harm first establishes that the harm at stake is permanent and non-remediable. Yes? And the lawyer then argues that because the harm is irreversible, the use of balancing test does not apply. Instead, the state must show that the dignity-preserving alternative could actually serve its interest. So if the state cannot make that strong showing, the irreversible harm cannot be inflicted. Now, in terms of theory number 8, the argument of irreversibility cautious reasoning. The irreversibility cautious reasoning is a new mode of constitutional adjudication distinct from supplementary to proportionality analysis. It argues that liberal constitutional reasoning, as theorized by Dawkins and Alexi, systematically under theories of irreversibility, the law must develop a mode of thought that takes seriously what cannot be undone. So the theory does not abandon proportionality. It supplements it. So before any balancing occurs, the court must identify whether the harm at stake is reversible or irreversible. If it is reversible, the structure of the analysis changes. The court must engage the irreversibility conscious reasoning, not merely proportionality reasoning. Okay, so irreversibility conscious reasoning requires courts to ask the 3 questions, for example, before any balancing. First, is the potential harm irreversible? Second, what is the degree of certainty that this harm will occur if the state acts? Third, are there less restrictive alternatives that would actually avoid the irreversible harm entirely? Or only after answering this question does the court proceed in terms of balancing? And even then, the weight assigned to irreversible harm is qualitatively different from the weight assigned to reversible harm. So why this matters in terms of jurisprudence? Proportionality analysis has actually been a dominant mode of constitutional reasoning for decades. So irreversibility in terms of conscious reasoning argues that proportionality alone is insufficient. It must be supplemented by a prior inquiry into the nature of the harm at stake. Now, we have to understand the novelty here. The novelty here is that the theory raises the question of whether courts currently have the doctrinal tools to distinguish irreversible from reversible harm. It argues that they do not, and the new tools must actually be developed. It also raises the question of what evidentiary standard should actually apply to claim the aspect of irreversibility. Yes? So when who benefits then? The courts benefit from a core sophisticated analytical framework. Litigants benefit from a mode of reasoning that takes finality seriously. Legal scholars benefit from a new research agenda. Very important. Now, how can this be employed? Courts applying irreversibility conscious reasoning would begin its analysis not with balancing, but with classification. If the harm at stake is reversible or irreversible, only after answering that question would the court proceed in terms of proportionality. So through the analysis, the court would give distinct and greater weight of irreversible harms. Okay, now let me go to theory number 9. In terms of the theory number 9, it would be what they call the temporal presumption doctrine. The temporal presumption doctrine. So the temporal presumption doctrine adds a temporal dimension to the cluster. How? The longer the state detains without trial, the weaker its moral authority to deny temporary, human relief, even before mandatory bail thresholds technically crystallize under positive law. Time itself generates a constitutional presumption against a continued exercise of state coercive power. So the doctrine is grounded in constitutional philosophy underpinning mandatory bail provisions and extends that philosophy beyond its strict technical thresholds. Mandatory bail is not merely a procedural entitlement triggered by time. It is a constitutional warning against the normalization of prolonged pretrial detentions, even where the statutory threshold has not been reached. The passage of time weakens the state's moral authority to continue the detention. Fundamentally important. So the doctrine also operates as a sliding scale. So at the outset of detention, the state's authority is strongest. As time passes with trial, that authority diminishes. Eventually, even before mandatory bail threshold are actually reached, the state must show not only that the detention remains lawful, but it remains necessary and proportionate. So the presumption does shift. Time creates a burden on the state. Why this matters? The temporal presumption doctrine introduces a time of what they call freestanding constitutional factor. Time is not merely a trigger for statutory entitlement. It's a constitutional variable that affects the weight of state interests and the burden of justification in that context. So in terms of the novelty here, the doctrine raises the question of what temporal duration triggers in terms of a shift in presumption. It also raises question whether different types of detentions, whether criminal, whether immigration, whether mental health, have different temporal thresholds. Yes? So who benefits? In terms of the long pretrial detainees, they benefit directly. Courts benefit from a clear temporal framework, and legislature benefits from guidance on mandatory bail thresholds, which is a fundamental in terms of today's occasions around the world, but also particularly in Uganda. How can this be employed? The lawyer invoking the temporal presumption doctrine would actually, calculate the duration of the client's detention and argue that the passage of time has shifted the burden to the state. The state must now show not merely the detention was initially justified, but that it remains justified after the passage of significant time. If the state cannot make that showing, release is required. And that is fundamental in terms of the discussion that I'm presenting as a new dispensation for the subject of criminal law. Now, let me argue cluster 3. Cluster 3 has to do with the bail and detention cluster. And in cluster 3, I have 5 theories that I've come up with. Now, the cluster comprises basically of 5 theories developed primarily through the Mufumbiro saga in terms of the Ghana jurisprudence. Some of you know the Mufumbiro case. And I have presented this before the Columbia Commission with roots in terms of the treatment of Ubuntu as restorative justice. So together, I'll constitute what they call a relational theory of pre-trial detention that challenges individualistic framework for conventional bail jurisprudence, for example. Now, let me argue for you the problem that demanded this cluster. The problem that demanded this cluster, for example. Conventional bail jurisprudence is actually built on methodological individualism. It asks about the individual accused. In terms of flight risks, in terms of criminal record, ties to the community, danger to the public. It does not ask about relational harm. It does not ask what pretrial detention does to the accused student or aging parents or dependents or employees of the community. It does not even ask about the social rupture that detention causes, not just to the individual, but the entire web of relationship constituting their personhood. Yes? And so the dignity on Ubuntu's account is not merely an attribute to the isolation itself. It encompasses the relational bonds through which the self is constituted and maintained. A deprivation that serves relational bonds inflicts a dignitary harm or as a qualified different kind of deprivation that must restrict movement. So current bail law has no category for this kind of distinction. So the bail and detention cluster addresses this gap. Okay, and that is fundamentally important. We should argue in terms of theory number 10, what I call the compassionate bail test. The compassionate bail test is a structured 4-limb bail assessment to cases involving exceptional human circumstances. For example, where all 4 limbs are certified, denial of temporary release is presumed unjustifiable. The test does not introduce discretion into bail law. It disciplines it, providing courts with a structured framework for engaging with the relational and dignity dimensions of a pre-trial detention decision. Yes? So I would argue it in terms of the concept of the 4 limbs that are within this concept. The first is whether the event is irreversible, such as a burial or even a final medical procedure. So the limb identifies events that cannot be repeated or remedied. So a missed burial is a gone forever. A final medication procedure that occurs without the accused presence cannot be rescheduled. So these are not ordinary events. They are singular, irreplaceable human moments. So second is whether the attendance is central to the accused human dignity as a relational as relationally constituted, for example. So the limb asks whether the event is so centered to the accused identity as as a relational being that non-attendance would actually constitute a dignitary harm, beyond ordinary prevention. So for a parent, for example, to miss the child's burial, of a child is a parent's final moment. That harm is not merely emotional, it's existential to the relational itself. So the third is whether the risk to the state interest can actually be reactionarily mitigated through conditions or escort, for example. The point here is that an escorted release, or perhaps in terms of escorted or electronic monitoring, or perhaps in terms of fixed return dates, secure requirements, if mitigation is possible, denial becomes harder to justify. Then the fourth could be in the context of whether denial would actually result in disproportionate or even irreversible emotional and dignitary harm. This limb asks the court to weigh the harm of denial against the state interest. So where the harm is both severe and irreversible, the state interest must be correspondingly weighed to justify the denial. Why this matters in terms of jurisprudence? The compassionate bail test provides a structured alternative to the unstructured discretion that currently governs bail decisions in exceptional circumstances. So judges currently decide whether such basis on intuition or sympathy. So the test replaces intuition with analysis. So the novelty here is that the test introduces the concept of relational dignity into bail justification or jurisprudence, and it treats the accused not as an isolated individual but as a person embedded in relationships. So the significance a departure from is significant as a departure from conventional bail law as we know it. So who benefits? The accused person facing exceptional human circumstances benefit directly. Their families benefit. Judges benefit from a structured framework. Appellate courts do benefit from a clear standard of review. How is it employed? Lawyers, for example, representing a detained person whose child is dying, invokes the compassionate bail test and walk through court through each limb. Okay, so the lawyer shows that the event is irreversible, that the attendance is central to the accused in terms of relational dignity, and that the state interest can be mitigated, and that the denial would cause disproportionate or irreversible harm. And the court then applies the test and grants release unless the state overcomes the presumption. Now, let me take you to theory number 11, in terms of what they call the Ubuntu bail theory. This is another component also that we have come up with. The Ubuntu bail theory goes deeper than the compassionate bail test. It argues that bail decisions cannot be constitutionally sound if they ignore the relational dimensions of the accused person. Their communal embeddedness, their responsibilities to dependents and community, and their social rupture. That pre-trial detention causes not just to the individual, but to the entire web of relationship constituting their personhood. So a deprivation that severes, for example, relational bond, inflicts a dignitary harm of a qualitatively different kind of form from the deprivation that merely restricts movement. The Ubuntu bail theory provides a philosophical grounding for the compassionate bail test. It explains why relational harm matters constitutionally, not merely sentimentally. So the theory draws on Ubuntu's conception of personhood. Under Ubuntu, a person is not isolated as themselves. A person is a self-constituted through relationships. So to subvert those relationships is not merely a cause of pain. It's an attack on the very structure of personhood. So bail decisions that ignore relational harm are not merely harsh, they are constitutionally blind to what personhood actually means under Ubuntu. Now, when we argue in terms of why this matters in terms of jurisprudence, the Ubuntu bail theory provides a philosophical foundation of a relational approach to bail. It answers the question, why should courts care about relationships? Because under Ubuntu, relationships are not optional extras to personhood. They are constitutive to personhood. Now, why this is a novel issue, the theory raises the question of whether current bail law under implicitly assumed, the current bail law implicitly assumes an automatic conception of personhood. It argues that it does, and that this assumption is culturally specific and constitutionally problematic in Ubuntu-grounded legal systems. Who benefit? All accused persons benefit from the bail jurisprudence that takes rational harm seriously. So legal theorists benefit in terms of a clear articulation of Ubuntu implications in terms of the bail law, and law reform benefits from a philosophical foundation in terms of the reform. Now, how can this be employed? A lawyer, for example, invoking the Ubuntu bail theory, argues that conventional bail analysis is incomplete because it ignores rational harm. So a lawyer presents evidence of the accused communal embeddedness dependence in terms of community responsibilities, in terms of caregiving roles. The lawyer then argues that because dignity under Ubuntu is rational, a bail decision that ignores these rational dimensions is constitutionally unsound. Okay, and that is fundamentally important. Now, in terms of theory number 12, what they call the Muffumbiro test. The Muffumbiro test is a structured four-limb, relational bail assessment derived from the constitutional and Ubuntu analysis of the Muffumbiro situation. So each limb addresses a distinct relational dimension of the detention decisions that conventional bail assessment frameworks systematically do ignore. So the test is named after the factual situation that inspired it, ensuring that the human story behind the theory is not forgotten. Now, the four limbs would actually be the following. First is that what communal and relational harm does pre-trial detention cause beyond the individual accused? Okay, so these limbs direct the court's attention to the ripple effects of detention. Children without a parent, elderly parents without a caregiver, employee without a livelihood, community without a member. Harm is not limited to the accused. Okay, fundamental. The second would be in the context that it has a state demonstrated, the second has the state, for example, demonstrated that detention is proportionate, not just individually, but rationally. Accounting for communal impacts, for example. The limb shifts the burden. The state must show not only that the decision is proportionate for an individual accused, but that it remains proportionate when all relational harm is actually considered. And the third would be that there are Ubuntu consonant alternatives to detention that preserve communal relationships while serving the interest of justice. The limb requires a court to consider alternatives that uphold Ubuntu values, community-based supervision, restorative justice processes, and even reparative conditions. Now, the fourth would be in the context that does the detention, for example, decision honor or rupture the accused dignity as constituted through communal relationship. The limb asks an ultimate question: does this decision treat the accused as a person in community or as an isolated atom? Fundamental in that context. So why does this matter? The Muffumbiro test is the most comprehensive relational bail test in the framework. It addresses communal harm, it shifts the burden to the state, it requires consideration of Ubuntu consonant alternatives, and asks the ultimate question about dignity. No existing bail test does all these things, and that is the reason why I'm making a drum major to adapt that wonderful test. Now, the novel issue raised here, the test introduces communal harm as a distinct category in bail analysis. It shifts the burden of proof to the state to show how relational proportionality. It requires courts to consider Ubuntu consonant alternatives, not merely conventional bail conditions. So who benefits? Communities benefit from a test that takes communal harm seriously. The accused person benefit from a test that asks about their relational dignity. So courts benefit from comprehensive framework. How can it be employed? A lawyer, for example, invoking the Muffumbiro test, walks in the court through with all those four limbs, presenting evidence of communal harm, challenging the state or to show rational proportionality, and proposing Ubuntu consonant alternatives, and arguing that the detention decisions are currently structured, as currently structured, would rupture the accused relational dignity. And in terms of that, I would now argue what I would term Theory 13. The Theory 13 has to do with what they call procedural absolutism. Procedural absolutism. Now, procedural absolutism is the pathology of legal systems that elevate legal form over human substance, producing outcomes that are correct in form but catastrophic in consequence. So it's identified as a systematic condition, not as a judicial failing applicable beyond bail law to immigration, detention, mental health, refugee determination, all these areas in terms of that. And now the aspect here, legality without humanity, is the diagnosis. So a system that is correct in form but catastrophic in consequence, has actually failed, not because its procedures were wrong, but because its procedures were applied absolutely. So without regard to human consequences, for example, procedural absolutism names this failure and provides a framework for resisting it. So the theory also argues that a procedural absolutism is not inevitable, it's a choice through, though often unthinking one, okay? So courts choose to apply procedural absolute rather than contextuality. So they choose to prioritize form over substance. These choices can actually be unbent. So the theory provides a language and framework for unmaking them, okay? So why this matters in terms of jurisprudence? Procedural absolutism identifies a system condition that legal theory has long noticed but never systematically theorized. So everyone knows that the law can actually be correct in form but catastrophic in consequence. So procedural absolutism gives this condition a name and a diagnostic framework. Now, why this is a novel issue? It's a novel issue in the context that the theory raises the question of whether procedural correctness can never be a free, can never be a defense to catastrophic consequences. So it argues that it cannot. It also raises the question of how to distinguish legitimate procedural rigor from pathological absolutism. Okay, so who benefits? Every person who suffers catastrophic consequences from formally correct legal decisions benefits. Courts benefit from a framework for recognizing and resisting absolutism, and law reformers benefit from a diagnostic category. How is it employed? A lawyer, for example, invoking procedural absolutism, argues that while the state has actually followed correct procedure, the result is catastrophic and that the procedural correctness is not a defense. So the lawyer asks the court to recognize that it has a choice between absolutism in terms of or against humanity, and to choose humanity in that context. And then I'll argue theory number 14, what I would dub the humanitarian release doctrine. So the humanitarian release doctrine grounds the entire cluster in international humanitarian law. Okay, it demonstrates the international human rights law already contains the normative resources for humanitarian release, as doctrinally grounded principles of detention law. Yeah. So what is missing is the doctrinal structure to give those resources effect, and the doctrine provides that the structure anchored in the ICCPR in terms of Article 9 and Article 10, the Human Rights Committee's General Comment 35, the Nelson Mandela Rules, and the African Charter of Human and People's Rights. The argument is not that international law should be changed to accommodate humanitarian release. The argument is that international law already requires it. So courts simply lack the doctrinal framework to see what is already there. So the doctrine synthesizes existing international law provisions into a coherent framework for humanitarian release. When you argue Article 9's guarantees for liberty and even the security of persons, Article 10's guarantees for human treatment, the General Comment 35 elaboration in terms of the presumption of liberty, Nelson Mandela Rules emphasizes on the aspect on the release of restrictive alternative, the African Charter protection of dignity. So together these provisions require humanitarian release in case of exceptional human circumstances. So why this matters in terms of jurisprudence? The humanitarian release doctrine transforms humanitarian release from a matter of judicial mercy into a matter of international legal obligation. So this is a significant shift in terms of mercy is discretionary, obligation is not. Now, in terms of the novelty, the doctrine raises the question of why humanitarian release has not been so underutilized, despite the existence of the relevant international law. Yes, provisions. So it argues that the missing element is doctrinal structure, not normative content. Now, who benefits in terms of the 10 persons? We're arguing that the 10 persons would actually be, in exceptional circumstances, by the way, benefit from the doctrine grounded in international law. So courts benefit from a clear international law framework, and human rights bodies benefit from a synthesized doctrine. So these are good takeaways in light of that. How can this be employed? A lawyer, for example, invoking the the humanitarian, release doctrine, cites the ICCPR Article 9 and Article 10 and the General Comment 35, the Nelson Mandela Rules, and the African Charter. So the lawyer argues that these provisions read together require humanitarian release in the client's circumstances. And the argument is not that the court should be merciful. The argument is that international law demands release in that context. And that is a fundamental takeaway in terms of these wonderful novel situations that we're talking about. I'll now argue in terms of what they call Cluster 4. Now, Cluster 4 is going to be in the context of what they call the semiotic and constitutional cluster. The semiotic and constitutional cluster is another issue that I have come up with as a new theory for the world today. And I'll break this in terms of three theories. The first is that the cluster comprises of three theories developed. primarily through the semiotic article that I submitted to International Journal of Semiotics of Law, under my doctoral thesis. Together, they constitute a structural diagnosis in terms of Ubuntu's absence from Ugandan constitutional because as a normative framework for constitutionalism or constitutionalization, if you like. So the problem that demanded this cluster is as follows, and it's very important for our argument here. Uganda's courts apply Ubuntu values operationally while remaining semiotically constrained from Ubuntu as a named constitutional signifier. So they produce outcomes that are Ubuntu consonant without ever citing Ubuntu. They speak Ubuntu without knowing its name. This is not a harmless accident. No. It's an inherent of colonial legal structures that actively suppressed indigenous justice mechanism as informal, subordinate, and legally unauthorized. So post-colonial constitutions inherited that suppression without dismantling it. So the result is that it's a structural gap that remains even after formal independence. Courts perform the normative work of Ubuntu jurisprudence while leaving the sign legally inoperative. So this semiotic estrangement, it is the constitutional pathology that we are talking about. Now, in terms of my theory number 15, what I would argue in terms of semiotic estrangement theory, it distinguishes between Ubuntu's normative content, which is present and judicially deployable. So, and Ubuntu is a constitutional sign, so which is suppressed and institutionally underdeveloped. The theory demonstrates that courts routinely apply Ubuntu values in their reasoning. They emphasize reconciliation, communal harmony, restorative justice, for example, and relational accountability, but they do not name Ubuntu as the source of these values. So the sign is legally inoperative while the substance is judicially active. So this is semiotic estrangement. It is the structural condition. Constitutionalization is the cure. The theory provides a diagnostic framework for identifying and measuring this estrangement. So the theory draws on semiotic legal theory, which examines how legal systems create meaning through signs. So a legal sign is not just a word. It is a word embedded in a system of meaning. So when Ubuntu presents a normative substance but absents as a legal sign, the system is estranged from itself. It's not doing Ubuntu work without Ubuntu authority. So why this matters in terms of jurisprudence, semiotic estrangement as a theory provides the first systematic account of why Ubuntu remains absent from Ugandan constitutional discourse despite being judicially deployed in substance. It identifies a structural condition, not a series of individual judicial failures. Now, this is novel in the context that the theory raises the question of whether a legal system can actually be said to include a value, or a value if the value is not named. It argues that it cannot. Naming matters, and science is not decorative, it is constitutive. Okay, so who benefits? Constitutional drafters benefit from understanding the semiotic dimension of constitutional inclusion. Courts benefit from understanding the significance of naming Ubuntu. Legal theories do benefit from semiotic framework of analyzing constitutional values. It's very, very important in the context of my discussion as another gift to the world, if you like. How can this be employed? The scholar or even a law, reform commissioner applying semiotic, estrangement, the theory would benefit in what we call audit judicial decisions to identify cases where Ubuntu values are applied without Ubuntu being named. So the audit would actually provide empirical evidence of estrangement, forming the basis of recommendations to name Ubuntu explicitly. Okay, and that's very important. Now, if I take you to theory number 16, in terms of the argument of Ubuntu decolonization deficit, the Ubuntu decolonization deficit theory explains the origin of the semiotic estrangement. Colonial legal structures did not merely ignore Ubuntu. They actively suppressed it as a legal sign, coding indigenous justice mechanism as informal, subordinate, and even legally unauthorized. The deficit is the structural gap that it remains. Okay, and post-colonial constitutions inherited colonial semiotic exclusion without dismantling them. Okay, constitutional renewal must address the deficit explicitly, not as a historical commentary, but as a program of active structural repair. The theory transforms decolonization from a historical claim into a continuing constitutional obligation. The work of decolonization is the work of dismantling colonial semiotic structures that persist in independent constitutions. Okay, so the theory also argues that decolonization is incomplete, or political decolonization happened. Okay, so legal decolonization did not. The legal system still operates within colonial categories. colonial exclusion, colonial silences. Ubuntu's absence from the constitutional sign system is not a neutral omission. It is an active exclusion inherited from colonial law. And that is something also why we need to address that. Now, why this matters in terms of jurisprudence, Ubuntu decolonizes deficit, provides a historical and structural explanation of Ubuntu's absence. It moves the conversation from blame to repair. So the question is not who fought this, the question is how to fix this. That is the most important aspect. Now, the novelty raised here is that the theory raises the question of whether post-colonial constitutions can actually be considered fully legitimate, and if they retain colonial inclusions. This argues that they cannot. Legitimacy requires not only independence, but also decolonization of the legal sign system itself. So who benefits? All citizens. For example, in terms of all post-colonial African states, for example, they benefit from the legal system that has actually completed the work of decolonization. So constitutional drafters benefit from a clear framework of addressing these colonial exclusions. How can this be employed? A constitutional drafter, for example, applying the Ubuntu decolonization deficit, would audit the existing constitution for colonial exclusions, identifying Ubuntu's absence as a colonial, as a colonial inheritance, and propose textual and institutional remedies to dismantle that exclusion. Now, in terms of my theory number 17, I would argue in terms of the Ubuntu constitutional dispensation theory. Yes, and under this Ubuntu constitutional dispensation theory, it provides the remedy, a new constitutional dispensation for Uganda, and by extension for African constitutionalism broadly. So it requires not merely textual amendment, but a fundamental reorientation of the constitutional science system. Ubuntu must become named, judicially operationalized, institutionally supported, and culturally grounded in terms of constitutional value. Now, a constitutional dispensation is not new because it changes text. It is new because it changes the sign through which the law constitutes itself and its people. So the macro theory that ties the entire Lubogo framework together and provides its normative destination. All 19 other theories are instruments of achieving this dispensation. And that is the point that I'm trying to make as far as this Lubogo framework is concerned. The theory, specifies 4 dimensions of a full Ubuntu constitutional dispensation. First, the naming of Ubuntu must appear explicitly in the constitutional text. Second, operationalization. Courts must have doctrines and tests that apply Ubuntu. Third, institutional support. Judicial training, court rules, and guidelines must reflect Ubuntu. Fourth, cultural grounding. The constitution must be intelligible and legitimate to the communities it governs. Yes? So why this matters in terms of jurisprudence? Ubuntu constitutional dispensation, and as a theory, provides a comprehensive framework for constitutional transformation. It goes beyond textual amendment to address institutional and cultural dimensions. It is not a theory of incremental reform. It is a theory of fundamental change in that context. So in terms of the novelty, we could argue that the theory raises the question of what constitutes a constitutional dispensation as distinct from constitutional amendment. It argues that the dispensation involves a sign system transformation, not merely a text change. The novel claim is constitutional theory in this past section. And who benefits? The entire nation does benefit from this constitutional dispensation that reflects its foundational values. Yes? So constitutional drafters gain a comprehensive framework, and courts gain legitimacy. And citizens also gain a constitutional that speaks to in terms of their normative language in that perspective. So when you argue that, how can this be employed? The Constitutional Assembly applying the Ubuntu constitutional dispensation theory would actually not simply add Ubuntu to the text. It would actually develop a comprehensive plan for naming, operationalizing, and institutional support and cultural grounding. The result would actually be a constitution that not only is legally effective, but culturally legitimate in that context. And that is another wonderful takeaway for the framework that is provided for the jurisprudence of this country and other countries. Now, in terms of cluster 5 is basically an argument in terms of the measurement and diagnostic cluster. I labeled these as the measurement and diagnostic cluster. And in these, I have 3 theories that are proponed in terms of the dispensation that I'm talking about this evening. This cluster comprises of 3 theories developed through the doctrinal analysis or dispensation that I've been doing at my PhD level or doctoral level in that case. It is specifically under chapter 4, the analysis in terms of the 45 Ugandan cases that analyze. So together they constitute an empirical analytical infrastructure through which the Ubuntu presence in terms of proximity or absence in terms of judicial decision making can actually be systematically measured and even evaluated. Now, the problem in terms of that, I would argue in terms of what they call the problem that demanded this cluster. The problem that demanded this cluster is premised on the fact that a framework is not only useful as its ability to be measured. If Ubuntu constitutionalism cannot be audited, it cannot be improved. If judges and scholars cannot tell whether a decision reflects Ubuntu values or violates them, the framework remains theoretical rather than actually operational. So the measurement and diagnostic cluster solves that problem. And that's very important in terms of the discussion. It provides an empirical and analytical infrastructure in terms of systematic evaluation. So this is the first systematic jurymetics, if you like, of Ubuntu jurisprudence. And this is fundamental in the context of this discussion. Now, theory 18 would be arguing in terms of what they call the Ubuntu divided index. So the Ubuntu divided index is a criteria based on jurisprudential measurement as a tool that scores the degree of which court's reasoning reflects Ubuntu values. It's applied across all the 45 cases that I carried out in terms of judicial decision in my doctoral thesis, and also in terms of the index that produced in terms of the structural assessment that allows systematic comparisons across jurisdiction over a period of time. So the index does not merely describe what courts have actually done. It measures the distance between what they did and what Ubuntu demands. So me, as Isaac, one of the most original analytical contribution in terms of African jurymetics, if you like, is this particular one. So a court cannot be given a score, jurisdiction can be compared to another jurisdiction, progress can actually be tracked over a period of time. So the index that I propose uses multiple criteria drawn from Ubuntu's normative content: relational reasoning, communal consideration, restorative orientation, dignitary attention, and procedural humanity. So each criterion is scored on a scale. The scores are aggregated into an overall index score. The result is qualitative measure of Ubuntu's presence in judicial reasoning. I've got about 2 minutes to conclude. Bear with me. So why this matters in terms of jurisprudence? The Ubuntu divided index transforms Ubuntu from a matter of judicial intuition into a matter of empirical assessment. A scholar can now say with data that 60% of decisions are Ubuntu consonant, but only 10% are explicit Ubuntu. And this is not speculation, it is a measurement. So in terms of novelty, the index raises the question of whether Ubuntu can actually be identified. It argues that while Ubuntu is not reducible to numbers, its presence in terms of judicial reason can actually be meaningfully scored. So this is a methodological claim with significant implication in terms of legal research. Who benefits? The legal scholars, for example, gain a lot of research methodology in terms of this, and also Law Reform Commission can actually gain audit as a tool. Okay, they can audit as a tool. And judicial training also institutes, again, a baseline for measuring training effectiveness, and also citizens can gain transparency in that aspect. And how can this be employed? A researcher can actually apply the Ubuntu dividend index, selecting a sample of judicial decisions, scoring each decision against the criteria, aggregates the scores, and then produces an index score for the jurisdiction or even a period of time. Yes, and the score can actually be compared across jurisdiction or even tracked over time to measure the progress. Fundamental and very important. Now, theory number 19. I said we have 20, so we're number 19. We have only 2 to go. The theory would be argued in terms of the 3-category typology. The 3-category typology is the classificatory architecture applied across all the 45 cases in the doctrinal thesis. So every judicial decision is classified into one of these categories. So for example, explicit Ubuntu describes decisions where courts name and deploy Ubuntu as a constitutional value. So these are the rare cases where the sign and the substance align. So the court says Ubuntu and applies Ubuntu. There is no estrangement. Now, in terms of Ubuntu consonant outcomes, describes decisions where courts produce Ubuntu aligned results without naming the value. So, there are cases of systematic or semiotic estrangement. The substance is present, but the sign is suppressed. So the court does Ubuntu work without Ubuntu authority. And then the aspect of Ubuntu absent harm that describes decisions where courts produce outcomes that actively rupture Ubuntu's rational norms. They are not cases where the deficit becomes harm. The court can only fail to apply Ubuntu values but actively violates them. Okay, so the typological reveals that the Ugandan courts have actually not been silent about Ubuntu values. They have actually been speaking Ubuntu without knowing its name. Okay, so most decisions fail into the Ubuntu consonant category. So explicit Ubuntu is rare. Ubuntu absent harm is so relatively rare but significant where it does occur. So why this matters in terms of jurisprudence, the 3-category typology provides a nuisance alternative to binary assessment of Ubuntu presence. Instead of asking whether Ubuntu is present or absent, the typology asks what kind of presence or absence, and this allows for more sophisticated analysis in terms of that. The novelty here is the context of the typology it raised, because the typology here raises the question of whether Ubuntu consonant outcomes without explicit naming are sufficient or whether naming is required. It argues that while consonant outcomes are actually valuable, they are incomplete. Okay, so full constitutionalism requires explicit naming. Okay, so who benefits? Legal scholars, for example, gain in terms of classificatory framework, and then courts can also gain self-awareness about their own reasoning patterns. Law reform, gains a diagnostic tool for identifying this kind of estrangement. Now, how can this be employed? The researcher may apply the three-category typology in reading each judicial decision and classifies it based on whether the Ubuntu is named, or whether the outcome is consonant with Ubuntu values, or whether the outcome actively ruptures the Ubuntu norms. So the resulting distribution provides a picture of Ubuntu's presence in the jurisdiction. Okay? Now, I'm now going to category in that theory number 20, which idea should be last. So it's called the BAT for Ubuntu test. The BAT for Ubuntu test. The BAT for Ubuntu test completes the cluster. Yeah, this is a causation style constitutional test modeled on the common law, but for test in negligence elevated constitutional jurisprudence. It asks single diagnostic questions in any legal proceeding or constitutional analysis. But for the absence of Ubuntu values in this decision, in this institution, or perhaps in this legal provision, would this harm injustice or accountability? Failure have occurred? Where the answer is no, a constitutional Ubuntu deficit is actually established and remedial intervention is actually justified. So the text imports the familiar but for causation standard from tort law into constitutional jurisprudence. In tort law, the but for test asks whether the harm would have actually occurred but for the defendant's breach. Here, the test asks whether the harm would have occurred but for the absence of Ubuntu values. So if the harm would have occurred anyway, the absence of Ubuntu is not in a causal significance. If the harm would not have occurred, but the absence of Ubuntu, a constitutional deficit is then established. That is very important. So the test transforms a philosophical claim about Ubuntu's importance into an empirical question about causation. This is not speculation. It is causation analyzed, important from tort law, and elevated into constitutional adjudication. And that is fundamental. And why this matters in terms of jurisprudence, the BAT for Ubuntu test provides a clear, justifiable standard for establishing that a particular outcome is attributable to the absence of Ubuntu. It borrows from the well-established legal doctrine and adapts it into a new context. The result is the test that is both rigorous and also familiar. Now, the novelty here in terms of an issue would be the test raises the question of whether causation analysis can actually be applied to the absence of a value. It argues that it can, and by treating the absence of Ubuntu as a counterfactual condition, this is a novel extension in terms of the causation doctrine. So who benefits? Courts can gain a clean test for establishing Ubuntu deficit. Litigants gain justifiable standards, and law reformers can gain a diagnostic tool for identifying causal relationship between Ubuntu absence and harmful outcomes. In terms of employment, we are saying that a lawyer can invoke the BAT for Ubuntu test and ask the court to consider whether the harmful outcome would have occurred if Ubuntu values had actually been present. If the court concludes that the outcome would have actually been different, then the lawyer argues that the constitutional deficit is established and remedy is actually required. And that is a very, very important aspect in the context of what I just presented. So listen, the reason why I am making this, being a drum major in terms of this, is the context of preservation for those who are coming after us, or those who are already in the system, the preservation of now and the future, the preservation, as a mechanism, of certain things that are already in place. So the Lubogo framework is already preserved through multiple mechanisms operating in parallel. First, for example, we could argue in terms of official intellectual property record, which is actually dated April 2026, published by sui generis publishers in Kampala. So every one of the 20 theories is actually recorded in its definition in terms of key formulation, but also in terms of a source document. And the second is that the framework is actually embedded in 5 separate peer-reviewed journal submissions to the International Journal for Semiotics of Law, the Columbia Human Rights Law Review, the Yale Journal of Law and Humanities, the Harvard Human Rights Journal, and the East African Law Journal. Peer review is a gold standard for scholarly preservation. So the third is the context that the framework is actually anchored on an ongoing doctoral thesis at Makerere University Law School as an academic institution worth of permanent archival infrastructure. And then the fourth is in the context that the framework is actually published in open sources through sui generis publishers, ensuring that no paywall prevents access to courts. So lawyers, scholars, or citizens of Uganda and across Africa can actually engage this particular dispensation in terms of the Lubogo framework. Now, In terms of future preservation, I would recommend that the judicial, first of all, in terms of judicial citation through Uganda judiciary, should actually be encouraged to adopt the Lubogo framework as a formal sentencing and bail guideline, ensuring that the 20 doctrines become part of the routine judicial practice. And then second, law schools and curriculum could actually integrate them. The 20 doctrines could actually be taught in constitutional law or criminal procedure, and then in terms of jurisprudence courses at different universities in the country and other law schools and around the world. And then the third is the legislative reference. The Ubuntu deficit and the compassionate bail test should actually be incorporated into new Uganda bail guidelines, bail guidelines, and the criminal procedure code amendments currently under consideration. And then I would argue in terms of the fourth that it would be actually wise to digitally archive this. The framework should actually be deposited in the African Court on Human and People's Rights Digital Library and the Uganda Law Reform Commission Archive and the Social Science Research Network for Permanent Digital Preservation. And then fifthly, in terms of translation, the 20 doctrines should actually be translated into languages like Luganda, Lusoga, Swahili, Luo, Ateso, for the community in terms of legal education, ensuring that the framework belongs not only to the lawyers but also the people whose lives it's meant to preserve or to serve in that context. And how is this relevant in terms of the future benefits? I'll be quick to add that in the next 5 years, for example, the first Ugandan Court of Appeal decision citing compassionate bail test as a binding rationale is likely to appear. And this is something that we are making, being a drum major for. Perhaps in the 10 years to come, the Ubuntu Dividend Index may actually be adapted as a continental metric for the African Commission on Human and People's Rights. And then maybe, who knows, in the next 20 years, the if-but principle may actually be incorporated in the African Charter in terms of Charter's interpretation protocol for irreversible harm cases. And then who knows, in the next 50 years or so, the Lubogo framework will be part of the African, canonical jurisprudence taught alongside South African cases like S versus Bukwanyani, in terms of judgment as operationalized in terms of the Ubuntu framework that has transformed the philosophical tradition into constitutional diagnostic tool. And these are fundamentally important in terms of the future. So we're excited from Sui Generis. We are grateful to God for having given us the grace and the opportunity to come up with these wonderful inventions, if you like, in terms of scholarism. So the point here as a closure is that the law is not rigid. It is rendered rigid by the timidity of its interpreters. And so the aspect here is that the Lubogo framework, that in terms of Ubuntu constitutionalism, is an invitation to courage. It offers 20 original doctrines tested through peer review, grounded in doctrinal research, and organized into 5 clusters. It diagnoses the Ubuntu deficit, it provides tests to measure, it offers remedies to cure it, it gives courts a structured framework for irreversible harm, it gives detained persons a doctrinal basis for compassionate release, it gives constitutional drafters a theory of semiotic transformation, it gives scholars and law reformers an empirical methodology for measuring Ubuntu's presence in judicial reasoning. And fundamentally, this framework does not ask Africa to abandon modernity. It asks modernity to remember that law was never meant to be rigid. It asks African legal systems to complete the work of decolonization by restoring Ubuntu as a named, judicially operationalized, institutionally supported, and culturally grounded constitutional value. It asks court to justify not only what they do not, but what they refuse to do. It asks all of us to recognize that some harms are reversible and that law must develop a mode through that takes seriously what cannot be undone. So when law forgets humanity, it does not become stronger. It becomes irrelevant. So Lubogo framework is a reminder, and a toolkit, if you like. It's a record of what has been theorized. It's a map for what must be done. It's an invitation to every judge, every lawyer, every law student, every citizen, every future generation to complete work that colonial law left unfinished. Thank you very much. My name is Isaac Christopher Lubogo. Find us at Sui Generis. God bless you.